Yeah.
Hello, my name is Rachel Moran. I'm a professor here at Texas A&M University School of Law, and I wanted to welcome all of you, both here in the room and remotely, to this session on a landmark in Jeopardy, Texas and the fate of Plyler versus Doe. Before we get started with the program, I just had a few announcements about logistics and some acknowledgements. So first of all, if you are obtaining CLE credit in Texas for this event, you can scan the QR codes that are at the entrance at either door, or if you're joining us online, we will be sharing a link to the QR code at the end of the roundtable presentations. Also, if you are here in the room, we'll have our roving microphone with Rene Garces to take questions. But if you are joining us remotely, you can put questions in the chat function, and my research assistant, Elena Luna, will be monitoring the chat to share your questions with the panelists. I also want to express my appreciation not only to you for coming today, but also to the organizations and individuals who made this event possible. We're grateful for the support of the American Bar Foundation and Texas A&M University School of Law. I'm especially grateful to my research assistants, Armand Avila, Rene Garces, and Elena Luna, who have really worked tirelessly to conceptualize the program, identify speakers, and make sure that all of you have a great experience. I just want to give them a round of applause because they've done so much work. And I also want to thank Kelly Schmidt and Kirsten Evans, who coordinated travel and logistical arrangements for this program. And now to the program. As you know, the United States Supreme Court in 1982 decided Plyler versus Doe. And there the justices, it was a split opinion, but they ultimately, by a narrow majority, concluded that undocumented children have a constitutionally protected right to attend public schools. The case has its roots right here in Texas, as I'm sure the panelists will tell you about. The legislature passed a bill that allowed local school districts either to bar these students altogether or charge them tuition, which for many would have been tantamount to excluding them from the schools. And some districts took up the invitation that the legislature offered and instituted bars, which triggered the litigation that ultimately led to the Supreme Court's decision. Now, while this case was pending, a lot of people thought that it might be an opportunity for the court to recognize a constitutionally protected minimum right to education. In another case that came out of Texas about a decade before, San Antonio Independent School District versus Rodriguez, the court had said there is no constitutional right to equal education, but maybe there is a constitutional right to minimum access to education. The court declined to find a right to minimum education in a case involving students who did not speak English and received no assistance. Instead, it went off on statutory grounds. So many thought maybe this is the chance for the court to give real meaning to minimum access to education, but that was not to be. Instead, the court concluded that education is not a fundamental right. It never reached the minimum access question. It just said, in general, this is not a fundamental right. And immigration status is not suspect. So we're going to apply rational review under equal protection instead of strict scrutiny. But the court said this statute is so irrational that it actually cannot survive even a relaxed level of scrutiny under equal protection. As the district court judge had said, it was a ludicrously ineffective way to deter immigration. Now, recently, Governor Abbott here in Texas has said that the case that he would like to see the court overturn is Plyler versus Doe. So we think that Plyler may well be in the crosshairs for another challenge and another round of Supreme Court review. And so we find that this is an incredibly timely topic, and we're fortunate to have a group of speakers who can really address this from a variety of perspectives. What I wanted to do is introduce them in the order in which they will speak. And we're going to start with Paige Duggins-Clay. She is Chief Legal Analyst for the Intercultural Development Research Association. She leads the legal strategy expert testimony and amicus advocacy there. Prior to joining IDRA, Ms. Duggins-Clay was an associate at Husch Blackwell, LLP, and clerked for Texas Supreme Court Justice Jeff Boyd. She was named a top 20 up-and-coming lawyer by the Austin Black Business Journal in 2019. Sabrina Rodriguez is a staff attorney at the Mexican American Legal Defense and Education Fund. She's involved in litigation advocacy in education, employment, immigrants' rights, and political access. Before joining MALDEF, she was a clinical fellow at the Immigration and Human Rights Clinic at St. Mary's Center for Legal and Social Justice. Jessica Lander is a faculty lecturer at Tufts University, as well as a teacher, author, and advocate specializing in immigrant education. She was the 2023 Massachusetts History Teacher of the Year and a 2021 Global Teacher Prize finalist. She is the author of Making Americans, published in 2022, and that book includes many important narratives about education and immigration. But one of those is the story of Plyler versus Doe. And I've read this, Pat, and it's very, very beautifully done. She's co-founder of the National We Are America project, which amplifies student voices. And she is a Reimagining Migration Fellow and former Emerson Collective Fellow. Last but not least is Dr. Celina Estrada Thomas, who is Executive Director for the Texas Association of Latino Administrators and Superintendents and an Executive Coach for the Texas Association of School Administrators. She dedicated 41 years. Wow. That is. To Texas public education before retiring in August 2023, after serving for 6 years as superintendent of Hutto Independent School District. Under her leadership, the district expanded dual language campuses, prioritized equitable access and high expectations for all students, and improved academic outcomes. And so now I wanted to turn to our roundtable discussion. So I'm going to move over here to make it a little bit more conversational. And we're going to begin with Paige Duggins-Clay. And my question for you is, how does the current legal landscape surrounding Plyler versus Doe impact efforts to promote educational equity for undocumented students?
Thank you, Professor Moran. Can y'all hear me okay? And thank you to the A&M School of Law, all the fabulous partners, and particularly to Elena, who is my fabulous liaison to get me here and support this amazing programming, and all the RAs who did this great work. I'm Paige Duggins-Clay. I have the immense privilege of being the Chief Legal Analyst at IDRA. And you've heard a little bit about our organization already from those introductory remarks. Our organization was founded by Dr. Jose Cardenas, who was the superintendent of Edgewood ISD. Over 50 years ago, he looked around at his beautiful community and school district and saw that despite the fact that his students were thriving and excellent and high achieving, when he looked across the highway, right, looked across the neighborhood and neighboring school districts like Alamo Heights ISD, there was not equal funding, not equal resources, let alone equitable ones, and had a crazy idea that all young people deserve to go to a high quality public school that prepares them for college and for life. So he, in his role as superintendent and later in founding our amazing organization, IDRA or IDRA, led a coalition of students, families, educators, and community members to the U.S. Supreme Court in a landmark Supreme Court case, San Antonio versus Rodriguez. You heard, unfortunately, that vision was not realized of having a fundamental right to education under the U.S. Constitution in the Supreme Court, but didn't give up and came back to Texas and got to work realizing that and remaking the face of school finance in Texas. And I appreciate starting there because that's really grounded our mission and later grounded our organization's work to the present conversation, right, which is a conversation about Plyler v. Doe. Our organization was deeply involved in the policy and the legal advocacy that led to the case. Our founder, Dr. Cardenas, and our director of policy at the time, Dr. Albert Cortez, were both expert witnesses in the various litigation that came up. And I had the opportunity to talk with Dr. Cortez about it and encourage y'all to check out that podcast recording. He's a national treasure and a wealth of information. I want to start just by framing that the moment that we're in right now matters, and it feels very similar to the moment of how Plyler veto got started, right? In 1975, there was a backdoor amendment at the Texas legislature to ban students who did not have legal status from attending our public schools and allowing schools to charge tuition to them. And that is what gave rise to the litigation. And unfortunately, laws and policies just like that are being proposed now and again in the Texas legislature. But there's some really important things that have changed. I always try to I like to come back to being hopeful. You know, and the framing of the question is about how does this landmark decision of Plyler, which was litigated in the federal courts, ultimately achieve this important, cherished principle, right? That no child should be left out of the promise of public education. Every child is valuable, none is expendable. At the time, the state of Texas and our founder talked a lot about this, ruthlessly sort of pursued this idea of pushing undocumented children out of our schools. And unfortunately, many school leaders did the same thing. And I'm really proud, and I have my friend here representing our school administrators, right? I'm really proud that 50 years later, 40 years later, that's not the case. Our educators value our young people and are some of our strongest partners, and rely on Plyler to push back against harmful efforts from the state and the federal government. And it's really refreshing as an attorney at the organization. One of the most important things I do is field calls from my educator administrator friends and provide support and resources and referrals for those on the front lines doing this work. And so that is one way that the law, the actual legal case of Plyler, undergirds and supports educational equity for all children, but including and especially children who may not have legal status in their family. Lastly, I'll just point out that despite, I know we'll talk here in a minute about how the law is at risk and how it's being threatened, but this is really strong law and guidance, and that is grounded in values that are shared by so many people. And I know that the narrative and the actions, it's not just narrative, right? We know that our immigrant families and communities and broader communities that may be unfairly proxied in that way are under attack and being targeted and being harmed. But the good news is that lots and lots of people understand how important it is for us, for the soul of our nation, for our economic prosperity, for our civic development and engagement, and for educational opportunity, right, for all young people, including and especially immigrant children. And that's the other thing I'm really proud about that our organization has done, is building up the coalition of business, higher education, education justice, educator, and attorney groups that to really support and defend this important law and make sure that our young people have access.
And
You want me to do that all over again?
I didn't know if anyone else wanted to add anything in response to that question.
No, just to reiterate Paige's comments about IDRA being a resource to public schools. It put out some amazing literature and support resources. And I know that I personally share that information directly with superintendents, assistant superintendents, campus principals. So it goes directly to them. And most recently, some of the resources they put out were about supporting families and supporting students. And most importantly, and I'm getting goosebumps, is making our kids feel safe at school so that our children could continue attending schools. So for me and my organization, we rely on organizations like IDRA to help us with resources and help us answer those legal questions. Most recently, there was a superintendent on one of the school districts along Highway 77, and they had put out a notice that the Border Patrol was going to be stopping school buses. And I immediately responded, they cannot load your buses. All right, make sure that you instruct your bus drivers that they are not to let the Border Patrol on the buses. And if they have any problems, they are to call you, and you can go and confront them. The Border Patrol has no business loading or coming on board our school buses and taking or even threatening our children or asking them about their citizen documentation. Can you imagine a kindergartner having an ID card that says they're a citizen or not a citizen? I mean, who carries that information? It was just ludicrous. So anyway, I can really get on a platform here, so I'm going to stop.
And anybody else want to add anything before we move to the next question? Okay, then our next question is actually for Sabrina Rodriguez. And when I was summarizing Plyler, one of the things that I didn't mention is that it includes a passage on the fact that these undocumented children are persons residing in the jurisdiction. So Texas had said, no, they don't reside in the jurisdiction because they don't have documented status and they can't expect to be here permanently. The court said, but they do reside in the jurisdiction. They have to abide by all the laws and they pay taxes directly or indirectly through rent, indirectly or directly if they owned property. And so they are within the jurisdiction. So they get equal protection coverage. And then the court went on to the rest of the analysis of equal protection. That discussion of resident in the jurisdiction has gotten newfound attention because of attacks on birthright citizenship. And of course, there are people who are worried that we will also see the equal protection analysis crumble. So my really big multi-part question for you is, what do you think is going to happen if the Supreme Court takes up a new version of the Plyler kind of problem?
Yes. So first I'll say thank you again to Professor Moran for putting this panel together. And I'm very honored to be in such esteemed company up here. Our friends at IDRA and we are honored to represent Dallas over at MALDEF in different forms of litigation. And this is such an important topic. And it's one that is personal for me in my research, but also, in my personal life, I have a connection to this issue. But turning back to your question, in turning over Plyler, this $1 million question, what happens if Plyler goes away? What if this analysis crumbles in the future? I'm reminded of these two adages that my mom likes to repeat to us in that really annoying way that moms are always right about everything. The first is that when people show you who they are, you should believe them, right? And I think that the Supreme Court has already showed us that they are not even just capable, but, are inclined to revisit constitutional precedent and, land a different way. And I think we see a really prime example of this in the Dobbs decision. But I think it's important too that we don't just look to Dobbs. I think we have to kind of zoom out a little bit and look at the way we arrived there. So without boring anybody too much in the little minutia of the case law, for a while the precedent on precedents, if you will, was Citizens United, right? And so that case followed a framework of 5 sort of factors that the court looks to in deciding whether or not it should overturn precedent or whether on the basis of stare decisis. Stare decisis require that we stand by this precedent, okay? And so they follow that framework. And then we later see in a different case, Janus versus, I think it's called the Association of County and Municipal Employees, or it was a union of some kind. And in that next case, we see that the court is more inclined or spends more time evaluating whether we should stand by precedent on the basis of the quality of the reasoning that the court initially utilized to reach its rule. And so uses the same 5 factors that we originally saw in Citizens United, but sort of putting a finger on the scale, right? Sort of over-relying on this quality of the reasoning factor. And then we arrive at Dobbs, this last sort of case that I'll point to here, where it collapses 2 of the factors we previously looked to in that schema of 5, and then added an additional factor, which I would argue is just an expansion of the quality of the reasoning factor. But all of that to say, without getting lost in the weeds of those details, is we just see this little shift over and into allowing the court to revisit precedent and land a different way based on the subjective review of whether we like the way you arrived at your original rule. Do we like that or do we not? And so my takeaway here is that this little constellation of cases to me is indicative of the fact that, the court is capable and will approach this question, approach a revisiting of Plyler, the and land, differently than the way we originally did. I think that also there are also, this is not part of today's conversation, but I think that's there are also implications for the larger trust in our legal system, right? If we're depending so heavily on the quality of the reasoning, that's a lot of trust to put in the Supreme Court and how they're feeling today when this problem is before them. So that's the first part of my answer. But sort of to speak to Paige's remarks a moment ago, I'm inclined to the second adage that my mom likes to repeat to us, which is, let's not borrow tomorrow's trouble today. Today, Plyler is the law, is the law, is the law, period, full stop. And there are organizations, advocates on the ground monitoring and closely watching to make sure that this remains the case. But I think it's important that we continue to have these conversations. That's why I'm so grateful to Professor Moran for putting this program together. But also, I'm looking into the audience at future advocates. This is an important issue. Stay tuned in. I know it's easy right now with the just sort of waves of information and bad news coming our way at the federal and state level, but I think it's important to stay tuned into this conversation and to speak up for this issue. Yeah, that's what I've got.
Any follow-up comments?
Yeah, I'll just chime in briefly to say I'll join my fellow law nerd to talk. I also teach on the faculty of UT, so I can't help it. But one of the reasons I love the case of Plyler v. Doe is, in addition to being this really important, cherished principle, right, is that it has an interesting nexus between the relationship of law and policy, right? And the way that policy advocacy is like integral to, and like all of the things that go into policy advocacy, right? Messaging, communications, research, evidence, information, all of that plays a hugely important role into how the law is developed. And Plyler is one of the best cases for that, because at its core, Plyler is a policy determination, right, by the court, and it's undergirded by strong legal principles, and that's why it is and continues to remain good law. But the court was very convinced by the arguments and the analysis and the evidence advanced by advocates who, by the way, were not all lawyers, right? Dr. Cardenas, our founder, Dr. Cortez, not lawyers, experts in the field, by the students and families and educators and community members who came out. And so I always love to flag that, because I think people, as my amazing colleague said, like in this moment, we feel a level of paralysis and fear and sort of resignation. And I'm here to say, no, there's a really important role for all of us to play in the story and in defending this important landmark piece. And I'm just going to read you some of my, one of my favorite sort of moments in the opinion that really captures this. And it says, even if the state, in addition to the pivotal role of education in sustaining our political and our cultural heritage, denial of education to some isolated group of children poses an affront to one of the goals of our Equal Protection Clause, the abolition of governmental barriers presenting unreasonable obstacles to the advancement on the basis of individual merit. And I thought that was a really savvy point that the majority opinion made, right? Because it speaks to not only for many of us here, certainly all of us on this panel, and I think many of us listening in today, not just sort of the moral imperative of protecting the right for all young people to have this opportunity, but that it speaks to the broader collective. And I think that is a really powerful counter narrative, right, to efforts to say that, oh, these immigrant children are taking what's ours. They're not contributing. No, they're paying taxes. They're being amazing citizens and contributors to our community, and wives and, aunts and teachers and business leaders. And so not ceding that ground to those who are trying to use messaging to build momentum and build power to try to roll back this important case. We have to be just as vocal and insistent and proud, particularly for those of us who have the privilege of speaking out and not having fear of reprisal in the same ways that our immigrant, colleagues may not have.
Any other comments on this particular question?
Not a comment, but a question for Sabrina and even Paige, for our listeners and for our people in the audience. What key organizations should we should we follow or be familiar with? Who's keeping an eye on legislation? Because this is what's happening, right? You hear President Trump making comments, you hear Governor Abbott making comments, and just instilling fear. But all of that to me is like subliminal messaging. And so at some point, someone's going to make a move and we have to be ready.
Yeah, certainly. I think first, I'll say, and MALDEF was, represented the plaintiffs in the Plyler case. So Plyler is very much our baby. We're here to defend this principle to the end, right? So, so that's, I'll say, MALDEF stands ready to, counter any kind of attack on Plyler. I think that there are, we partner, or not partner, I should say, we monitor challenges to Plyler on the federal and state levels. But I do think that our friends at IDRA do a really good job of putting out materials that are digestible and, very comprehensive in their analysis of, this is what we're facing, this is, why it's bad, and, a full overview of what we're facing or what we're up against. So I think those are my top.
Your top
I'm not sure. Yeah.
One that's different than the law side, because Paige, your comment on advocacy and the role and importance of folks standing up, the work that needs to be done in schools to break through the narrative that often exists of us versus them. And so often, I'll talk a little bit more in a little bit, but I'm first and foremost a public high school teacher. And too often in schools, we see a divide between recent immigrant students and students whose families have been in the country for generations. And I think the other aspect, in addition to the legal aspect, is how do we get schools, both students and educators, to really invest in immigrant origin students and see them as central and integral parts of the community. And that happens at the classroom level of using migration as a connection point between students versus a point of division. It happens at the school level of thinking about how do we celebrate and center migration, stories of migration in our curriculum, in our hallways. And so that when there are attacks or potential attacks or threats, that the whole community of the school rallies around our students because they are our students. And I think in some places, not everyone believes that our immigrant origin students are our students.
Right.
And so how do we center those stories of migrations in our curriculum? How do we center it in our halls? There are great organizations like the National Organization Reimagine Migration that's doing that work. And I think that gets to the advocacy point in schools that goes hand in hand with what's happening in the legal communities.
And that leads us to your question right on cue. So for Jessica Lander, how do educators currently uphold the principles established in Plyler versus Doe? And what challenges or policy shifts might they face in ensuring access to education if the decision were overturned? I guess we're still borrowing trouble against your mother's advice.
Absolutely. So as I said briefly, I've just the honor and joy of teaching recent immigrant and refugee students. I'm a public high school teacher down here from Massachusetts. And so I'm just really excited and honored to be with all of you. Thank you so much for having us. My students come from 30 different countries, from Colombia to the Democratic Republic of the Congo to Cambodia. And they bring extraordinary strengths with them into our classrooms, just as immigrant origin students do across the country. Today in the United States, 1 in 4 students, 1 in 4 are immigrants or the children of immigrants. And some of these are immigrants who have chosen to come to the US. Some are refugees who have fled their country. Some are stateless individuals. And of course, some of our students are undocumented. And so when we think about how do we uphold the key principles of Plyler in our schools today, I mean, there's the baseline level of legally, you are required to teach all your kiddos. You cannot ask for documentation status, and you must be like investing in every one of your kiddos. But let's go beyond that. because I see extraordinary ways in which educators are investing in the strengths of their immigrant students across the country, from single classrooms in North Dakota to entire school districts in North Carolina. And so I think thinking beyond just sort of the basic requirements of teaching kiddos to like really seeing all the strengths, and this has been mentioned so far on the panel too, of all the strengths that our immigrant origin students bring to our communities, to our classrooms. So I think of the strengths that are not often identified, not often valued, not often invested in schools, but my students are cultural and linguistic navigators for their families. They bring extraordinary knowledge gained from having lived in many countries and cultures. They have tremendous amounts of grit and determination. All of these are strengths that we want, that we value in our schools, we value in higher education, we value in careers. And so how are we investing in that? And I'll give you just a couple examples of Leah Jolke up in North Dakota, who is drawing on the strengths of immigrant students to help build connections between students who have been in the country a long time, their families have been in the country a long time, and newcomer students. They're publishing books. They're going to the courthouse, to the state houses and advocating for laws. I see the same thing happening in Maryland at a school, international school at Langley Park, where students are leaders in their community. I see that with my students up in Lowell, Massachusetts, where my students are publishing books, they're advocating for bills, they're creating lasting programs in the community that are keeping our communities safer, that are providing food assistance for communities. And so just thinking about the strengths of all of our kiddos, no matter where they come from, no matter their documentation status. Now, what's the impact we're seeing already? Plyler still is the law of the land, but we are already seeing a chilling impact. So I'll just give you a few numbers. An organization I know did a survey of teachers in the first months of school this year, and they found that 20% of teachers had heard anti-immigrant comments being directed at students, 20%. 23% heard staff making anti-immigrant comments. And 30% of immigrant origin students reported being bullied for being an immigrant. We are finding that teachers are reporting to us that they are least likely to report anti-immigrant bullying, and that non-immigrant students are least likely to intervene when they see their immigrant peers being bullied. And we're seeing the chilling effects since January of classrooms in communities across the country have much lower attendance rates. Up to 40 to 60% of students are not showing up to school because they are scared, rightly so, rightly scared to go to school. And so Plyler is still the law of the land, but we're already seeing an enormous impact in our classrooms and on our kiddos and our kiddos' ability to learn in our schools. And this has an enormous impact for our kids and our communities. So thinking about what could be the impact, I mean, as already our panelists talked about, that this is sort of central to what it means to think about equity in education, that we need to be a country that is investing in all young people, no matter their documentation status. This is best for our kids, of course, but it's also best for our communities. So Judge William Wayne Justice, who was the original judge in this case in Tyler, Texas, talks about if you don't educate all kids, then we're creating this lower class of uneducated folks who are going to be living in our country. And that's bad for communities. It's of course bad for the kids, but it's bad for our communities. So this will have a really devastating impact in schools, but I think also important to talk about that it's already having a really chilling effect.
Anyone want to follow up at all on that?
I'm happy to, because I'm so inspired by everything that's being shared and just the resilience of our educators. I have the privilege, in addition to being an attorney at IDRA, I'm a mom of kiddos in our Texas public schools. My daughter is a first grader and goes to a school that has a high population of low economic students, of immigrant students, of English learner students, right? And it is the most beautiful thing I have ever seen. It's a joy to be a part, like not only be an advocate, right, for immigrant students and for all students, public schools, but to now witness my own child benefiting from that. But I share that because exactly to add the anecdote to what the data you shared, I mean, our teachers at my daughter's school came to me and said, hey, we need help. Like, what are we going to share with parents who are asking us about, can I bring my child to school? how do we help parents who are afraid that when they come pick their child up, ICE is going to be waiting for them. And for context, in my community, this particular part of town was a place where in the last administration, ICE was rolling around this neighborhood. And so it was not a hypothetical concern. And, there's an expression, like when Harriet Tubman and her colleagues and peers like created the Underground Railroad, right? Like they weren't like, here's the Underground Railroad, like here's the sign, right? Like it was really subversive, and it was really about caring for one another and protecting human beings in the community, right? And despite efforts to dehumanize through the law, right, these young people and their families, we have to push back. And so there's some really, basic common like human things we can do. We can talk to our neighbors and the parents of like other kids. I mean, I'm literally a designated pickup person for multiple kids in my child's school, right? And that's just one way that we're going to provide this layer of protection and safety. We're putting out resources. We're finding ways to like shield students and families, right, as a community. And so again, I always people love to go to lawyers, as they should, and you should if there's an immigration issue, but there's a really important role that all of us can play, not only professionally, but as parents, as colleagues, as friends, as neighbors, as community members. And I just want to really emphasize that and just give major kudos to the educators who are doing that hard work and that hard work.
I can see why you were the history teacher of the year. What an honor and what passion. Yes.
Well, and this is you get the final question, Dr. Thomas. So what has the Plyler ruling's effect been on public schools in Texas, and how might overturning it impact the educational landscape here in this state?
I pondered that question because we got the questions in advance, and I was thinking to myself, so I started teaching when I was 21 years old, back in 1982, 83. That was my first year of teaching. And so this is when this legislation was put in place. So obviously, as a teacher, I didn't see the effect of it. I really didn't begin working with it until I became an administrator, and I had to oversee the registration of children and children coming into the schools. And I remember one particular school, I had a registrar and she's the person who registers the kids, that was not very kind to our parents, made them wait extra long and asked for unnecessary documentation. She and I had a heart-to-heart talk about what it was to take care of our families. So I don't want to get too much into the storytelling, but I don't know anything different. And look at me. And I think all of the educators who are in schools are probably, I think most teachers, and Rachel and I were talking about being more intentional about educating our teachers about the laws that are in place that protect children and protect families. Excuse me, I've got allergies and I've got a cough drop just so I don't start coughing like crazy. So I don't know any different. Even before I just retired, semi-retired in August of 2023. And for us, it was about really protecting all children. That's our mission as public school educators. We educate any and all who come through our doors. Now, what has the effect been on public schools? Yes, it does cost more money to educate children who do not, and this is not just for Hispanic children, Latin children, any child who does not have command of the English language will require extra resources. It's just the way it is, but it's no different than a child with learning disabilities or learning challenges. We try not to use the word disability, learning challenges. All of those children take extra support, extra resources. But let's look at some numbers. So in Texas, we have 5.4 million children in public schools. And because schools, you may not know this, but schools cannot collect information on citizenship. Right? Our only requirement is to establish residency. Does the child or does the family or whoever has legal guardianship of the child, do they reside within the boundaries of the school district? So when persons come in to register their child, we ask for proof of residency. And that's usually if they have bought a home, the sales contract, or they bring in a utility bill, something that shows that they are living at a particular residence. Cell phone doesn't count because you can put any address on a cell phone. But it's got to be the utilities to that particular residence, or if you live in an apartment, the lease agreement. And of course, if you're buying a house, that's that sales agreement. So of the 5.4 million children who live in Texas, some data sources, and I just did this on AI, because since we don't collect citizenship, roughly 2% of the children are undocumented. And I'm assuming this data came from Border Patrol over the years as they're collecting data as people cross the border. And that obviously doesn't include any other families that may have gotten across and not been part of those numbers. So that equates to roughly 110,000 undocumented children in the state of Texas. Now, I know I got a minute left, but I'll come back to that. As far as what has the effect been, schools are funded by enrollment, but also by ADA, which is average daily attendance. So every child is worth $6,160. Plus, and if the child is in a special program, then you get additional funding. It's called weighted ADA. If we were to stop educating undocumented children in the state of Texas, the impact would be about $677 million less going out to schools. But I ask, what would be the price of not educating the children? At some point, they're here, their families are working here, they're contributing citizens. And unlike the rhetoric that's out there, the majority of our families are hard-working families. They come here to improve their livelihood and the futures for their children. And so saving $677 million in one shot at a cost of how much in the future, I couldn't even come up with a number. And I'll stop there because my time's up, but I had more to say. I'll come back.
Anyone else want to add?
I'll jump in on the number because one could sort of see it as saving money, but public schools across the country are struggling with enrollment.
Yes.
And so rural communities, which are experiencing lower birth rates and changing demographics, are really struggling to keep public schools open. So if you start taking away kiddos, you start taking away money from the public schools and you start shutting public schools. This is happening not just in rural areas, this is happening in cities. So New York City, between 2016 and 2023, the number of schools with less than 200 students doubled. And they are closing schools. This is happening in all the major cities. So taking away lots of students, like, yes, you're saving money, but you're also taking away money from all the schools. And that supports teachers' salaries. It supports sports programs. It supports arts programs. It supports all of the different programs that we want to offer in our schools. And so this is not just hurting our undocumented kiddos, it is hurting all students.
It's hurting all students, especially dual language programs. So in Hutto, where I was superintendent, 50% of the kids who were in our dual language program, surprisingly, were monolingual children. The families who wanted their children to grow up speaking two languages. You know what the joke is out there among the tourists, right? You can always tell an American because they only speak one language. And it's so sad. So our dual language programs are finally gaining some traction, especially with recent legislation where you do get additional funding for dual language programs, and not just additional funding for the emergent bilinguals, for the children who really need to pick up English, but for any child who enrolls in a dual language program. So that would be a detriment, I think. Yeah, huge. Yeah, a huge disservice to our communities.
And I just want to chime in quickly just to note that, and this is I think an unfortunate mistake that policymakers and maybe even not made in bad faith, like statements that people make, which is English learner status is not a proxy for immigration status. There are hundreds of thousands of young people in our state, in our country, right, that have the opportunity and the ability to speak multiple languages, to learn English in addition to a language at home. who are here with, appropriate immigration documentation or who are citizens, right? And so really pushing back against efforts to compare apples to apples, because we see this a lot in the policy argument that will ultimately undoubtedly be a part of a future legal challenge to Plyler, which is trying to say, oh, well, the state of Texas is spending millions of dollars, on English learner and English learner instruction. And that may be true. It's a good thing. It's an asset, as my amazing colleagues have shared. And that is a benefit that is not just, aimed at our immigrant students or our undocumented immigrant students. So I think pushing back against that narrative and resisting the urge, even for us, right, to associate language learner status with immigration status is really, really important.
Right. Well, that concludes the roundtable portion. So for those of you with Texas CLE, we should be getting you the link to the QR code, but we also want to make sure to get your questions. And so Renee is going to have a roving mic, I think. Okay. And also we have questions from the chat. So Elena, do you want to start with the question from the chat?
Absolutely. So the first question we got from the chat is, the court in Plyler noted that there was little certainty that undocumented children would face deportation, raising the specter of a permanent underclass of if education is denied. The Trump administration would argue that removal of all undocumented persons is imminent, and the court has shown little appetite for fact-checking the administration. How might this play into the court's approach in revisiting Plyler?
I think it's going to be Paige or something.
I was gonna defer to I don't, I think I'm first. Repeat that last part of the question for me, Elena.
Absolutely. So the Trump administration would argue that the removal of all undocumented persons is imminent, and the court has shown little appetite for fact-checking the administration. How might this play into the court's approach in revisiting Plyler?
I'm happy
I'm
to
not
just
even
kick it
sure
off
how
with
to-
the initial thought, which is because I mentioned my love of being a law nerd. I mean, there were a lot of policy rationales underlying the court's decision in Plyler, right? I mean, so certainly the sort of certainty, I think, around like the fact that we are going to have here to stay, right? We're going to have young people who are undocumented in our community. So let's assume that is less certain. Even setting that argument aside, there's lots of other wonderful reasons that we have all talked about, right? That Plyler is great law, right? The human rights and dignity component, the vulnerability and lack of culpability of these young people, and the impact, the importance of education, regardless of where young people ultimately live or reside nationally or internationally, right? There's still a compelling argument to make about what are we doing for these young people as they're caught up in legal proceedings or stateless, as was mentioned, right? I would still argue that we have a responsibility under our Constitution to those young people as persons, right? To provide them education, because it doesn't matter where they go, they're going to need it. And if they go, to their country of origin or a different nation, they're still going to need the benefit of being educated to thrive and to survive and to live. And so, I'm thinking on my feet just a little bit. So I think it's a fair question, and the overwhelming sort of need and values that underlie the opinion greatly outweigh, I think, the chaos of the current administration. And it's honestly suspect immigration enforcement practices. I mean, we've already seen court decisions limiting the ability to do deportations, and I think there's an overreach there as well.
Yeah. And I'll just add to that, so of course, we've all heard some really great points about why, like Paige just said, why Plyler is good law. To respond to the question though, does this court even hear those arguments? I say this because, part of the Dobbs decision, part of the reason they did away with this, what was previously thought to be like a fundamental right, of course, they do away with this because they found no, right to abortion steeped in our nation's history and traditions, right? But to that, I would just add, well, whose history and what traditions are we looking to in that analysis? I don't have an answer for that. I think that to speak to the question, it's open-ended because we don't know how the court would take all of these factors, take all of these really great points, and how are they going to feed that through the stare decisis analysis that remains. I don't know. Reasonable minds would disagree could disagree on this point all day, but yeah, certainly an interesting idea to raise.
Just as a footnote, after Plyler, there was a legalization under the Reagan administration, so most of the kids involved in the litigation actually had a path to citizenship afterwards and did remain in the United States. And the other thing is, on your point that the court is so formalist now that they might not even care about empirical evidence, there's actually a defense of Plyler on formalist grounds that was written by Steve Calabresi and a co-author, because at the time that the 14th Amendment was enacted, we didn't have this extensive system of border enforcement that we have now. The border was very porous because we were sparsely populated. We wanted more people. And there wasn't even a really federally, designated kind of naturalization bureau. And so their argument is that at the time this was drafted, if you want to look at the intent and the language, there wasn't any real meaningful distinction based on immigration status. And so there wouldn't be any notion that the equal protection clause applies differently based on your immigration status, because immigration status wasn't really a part of the policy landscape at the time. So very interesting question. What about, do we have other questions on the chat or from audience members?
I have a question about how can administrators and educators best support these children? Like you said, I really appreciate the need to form community around these kids. What can people in that position do for those children?
Well, I think from an administrative lens, it begins with creating a climate of inclusivity, right? And embracing all of the children that walk through your hallways. I remember in Hutto is still a one high school town, and when you walk in one of the main hallways, it's got a world map, and there's pins. So every time a new student enrolls, from a country outside the United States, there is a pin there so that they can see all of the students who come into the school from different parts, and the kids are celebrated. But I would venture to say that's not the case in all school districts or all high schools. And I think one of the pillars for Talas, our organization, is a relentless commitment to our Latino learners. Obviously, we're about all children learning, but our organization has a specific lens on Latino children. Latino kids represent 53% of the student population in Texas. And so part of what we try to do is provide professional development and learning opportunities to bring our administrators together, regardless of background. While it's a Latino-based organization, our leaders come from all backgrounds and all ethnicities. And it's important for all of us to understand the unique needs of our learners, of our Latino kids, and really to understand the unique needs of children who are new to the country and new to a language. And those are all best teaching practices. I know, and you have to create the climate to have that happen, to embrace those unique learning needs in your classroom, and to know what to do. The best thing you can do is to offer training for teachers so that they know what to do when a student doesn't understand a language, whether it's Arabic or Spanish or German. I don't know if I answered your question, but it all boils down to the quality of leadership. And I know Rachel has some more comments to make about that.
Yeah, I'll jump in too. And just building off this. So I think there's sort of two tiers. So there's the rapid response. How can educators in this moment be supporting students given the threats to Plyler and given the threats generally to our undocumented students and our students from mixed status families? Indeed, actually in Massachusetts, we just put out a guide on this, which I'm happy to make available to everyone here. So on those, it's, do teachers know Plyler? Many do not. So do they know the law? That's really, really important. Then there's specific things. We could get into some of the nitty gritty. I won't get too deep, but there are things like student data, which is protected, sort of like medical data is protected. And then there's something called directory of information data, which is much more easily accessible. Now, directory of information data doesn't share that much information, but it does sometimes include students' addresses and students' country of birth. Now, of course, too, and going back to Paige's point, being an immigrant student does not equate to being undocumented. However, shining a spotlight on all of our immigrant students at this time is not a good thing. Now, you could remove the country of birth and the home address from that directory of information, which is accessible without permission of a parent. That's an easy thing schools could do right now, today. In addition, what happens if an immigration officer shows up at your school? What do you do? Many schools have maybe a basic protocol, but like that's a tense, anxiety-provoking situation. Do we have a very clear step-by-step protocol of what you do so that anyone in the school of administration and school staff knows exactly what to do without questioning, can just point going, I'm just following what I've been told. Now that's your rapid response. And then we get to the broader conversation of how do we create communities, how do we create schools that are investing in all of our kiddos, celebrating all of our kiddos. And that could be thinking about curriculum. That could be thinking about the books in our libraries, our classroom libraries, our school libraries. Do they reflect, can our students see themselves in those books? It could be thinking about things like the cafeteria, and I'll give you just a very brief example. My students each year write a cookbook, sharing favorite family recipes from all over the world. My kids come from 30 different countries. And a couple of years ago, the cafeteria team reached out to us and wanted to collaborate. And so now once a month, they work with my students to adapt one recipe that they serve, both in our high school of 3,500 students and across our district to 14,000 students. Now, where I teach, I'm on sabbatical this year, but where I teach in Lowell, Massachusetts, Lowell has the second largest Cambodian community outside of Cambodia. It's Cambodia, Long Beach, California, and then Lowell, Massachusetts. It was not until a couple of years ago, and from this project, that our district had ever served food from Cambodia in our cafeterias. And that might seem like a really small thing, but like these things matter. For students who are from, say, Cambodia or any other country, seeing their food represented in the cafeteria says, this has value here. And then for our students who are not from, say, Cambodia, get to learn from and get to be curious from and get to build connections with their Cambodian peers. And so thinking about like all sorts of concrete ways, both in the curriculum, the classroom, but also just what's happening in the halls, the cafeterias, how we're supporting and engaging families, all of that makes our students feel safe, feel seen and valued. And that's true for all of our students, whether they're immigrant origin or not. It's just generally good practice.
I think we have time for one more question.
Yes. Since we only have time for one more, I'll ask maybe two short questions. The first is two short questions. So you talked a lot about arguments for why we should embrace immigrants within our schools. When we're going out and about day to day and we encounter somebody who is against this idea, for example, you had a lot of good arguments for why we should do that. Which ones do you think are our strongest to have in our back pockets to interact with this person and maybe try and maybe get them to change your mind? Which arguments would be the stronger ones we should carry around with us to pull out?
I felt that there was gesturing towards me, so I'll start. And for my friends who also do advocacy excellently, it's a great question. And I'll give you the classic lawyer answer. It depends. It depends on who you're talking to, right? It depends on if you're talking to what level of, I guess, commitment to open-mindedness you're working with, right? So, but I'll just mention a couple that were compelling to the court and continue to be compelling to our partners across a lot of different ideological and places in like, advocacy and policy, like the business community, for example. So step one is we have to refute myths, right? So this notion that undocumented students are expensive and too expensive to educate and draining public schools, it's false. It's wrong. You've heard about when we remove any child, including an undocumented child, that's schools losing money, and not just the baseline money, but all the other money, the compensatory funding, both state and federally, right, that they generate because of their unique opportunities that we have to educate them, right? So they are paying members of our community through sales tax, through the rent that they pay, right? They are funding and subsidizing our schools, and so we must, support them. So that's step number one. And you can pick from, all that menu. I will tell y'all from I mentioned like the economic lens. So if you're talking to someone who's like business minded or saying, oh, people are taking all of our jobs, right? I have some of those crazy people in my family. And so talking about the economic power of our immigrant communities, our undocumented communities who are contributing, right? And the need for education so that power and opportunity can be magnified. And so that might be a really successful strategy. We have great partners in the business community in Texas and nationally who recognize that. And then lastly, I will just say, there's a really practical point. I forget who made it, one of these amazing people up here, which is, what's the alternative? Is the alternative, notwithstanding the first interesting question about like, oh, is deportation imminent? It's not. I'm just going to say that. But like, the alternative is now you've got children roaming the streets who, may not, right, like have support resources. Their families are hardworking people. They're unsupervised, right? I don't like to lean into like harmful caricatures of any child, but like we really at some level have to ask like, what's the alternative? And I think the benefits of education and support far outweigh sort of the alternative of what could be. And that's what the Supreme Court said when they said we would be creating a permanent underclass. And that's not good policy or good for kids.
And with that, our panel, let's have a round of applause. And we want to thank all of you for coming and appreciate the questions and your attention today. We agreed to stay a little bit longer if you want to have further conversation one-on-one. I think Justin's going to take a picture. So,